Hey everybody, welcome again to Tech Intersect, where technology meets the law. Today, I'm really excited to be joined by Stuart Levy, a recognized tech transactions and IP law stalwart. All of us wonks at the intersection of IP and this crazy, wild, wonderful world we know of cryptographically secured assets and distributed ledgers, blah, blah, blah. We look to Stu for his leadership and his guidance, and it's always a pleasure to connect with him on these topics. A bit more about his background with a career that includes pioneering work in Web3, AI, cybersecurity. He's absolutely shaped some of the tech world's biggest deals. And from his early days at Reuters to advising on major blockchain and AI initiatives, Stu's expertise has made him the go-to authority. And, I don't say that lightly, folks, because there's a lot of people piddling about at the edges, but he's the real damn deal on the digital age's pressing legal questions. We will talk about all of that and more, particularly at the intersection of copyright and AI in a moment. But first, Stu, welcome.
Thank you. Thank you so much for that very kind introduction. I've been called a lot of things. Stalwart, I think, is a first. So really appreciate it. And right back at you, Tanya, for all the exciting, interesting writings you've done and talks and work you've done, and also helping teach and mentor the next generation. Has been exciting to watch.
Oh, I appreciate that very much. Yeah, it's just, it's a passion. And I feel so fortunate to be able to do the things that I love, both as an attorney, but more importantly, as an academic, and also, the practical application of the things that we do in law school is critically important, probably
Right.
more now than at any other time. It's one thing to normatively pontificate in my law review articles, but it's another thing to really be on the front lines and to kind of build this plane while we're flying it, which makes it
Right.
quite exciting, right?
Right.
And so when I saw some of the information that you were sharing on LinkedIn, specifically about a recent copyright law case having a direct impact on artificial intelligence, we know large language models, ChatGPT definitely boomed in in this year, 2023. But it's an exciting time for the testing of the contours of laws to protect literary and artistic works. So I'm wondering how the emergence of AI generated content challenges the current framework of copyright law.
Yeah, no, it's a really, really great question. So, I guess let's take it in maybe three buckets. The first is using AI to generate a work. The second is using works to train an a copyrighted works to train an AI model, and the third is AI generated output and what are the risks of infringement and things like that. So let's take those in order and start. And I'll pause after each one and we can chat. So on the first one, so the Copyright Office has long taken the position that a copyright registration and courts have said copyright protection requires human authorship. As you can imagine, there have not been that many cases where that issue has been challenged. Probably the most interesting case prior to the advent of all these AI issues was their case, and the facts are interesting, and the way it came up legally was interesting. But there's a famous case of a nature photographer being out in the jungle, and a monkey grabs the wire that's the shutter release and clicks on it and takes a selfie, and it's cool, because selfie, it's monkey, whatever. The artist, the photographer does not try to claim anything about, well, the monkey should own the work or anything. Photographer, it's just another photograph, but then publishes a book, and the animal rights group says that it was wrong that you did not attribute ownership of this photograph to the monkey because the monkey took it. And the Copyright Office says you have to be a human, the monkey can't own the work. So there's a couple of unusual fringe cases like that. And that brings us then to the world of AI, where some of it's interesting and some of it isn't yet that interesting. So what I mean by that is, so there's probably the most famous test case the Copyright Office has had so far was brought by a guy named Thaler. A little bit of a character in that he's in it to prove a point. So Thaler took a position very different from what some other people have taken, and has argued, almost like in our monkey example, that I built this AI model. This AI model generated this artistic work, and the AI should be deemed the author of that work. I'm not claiming I should be it, which you see sometimes. You shouldn't pay attention to the fact that it was AI generated. Here, Thaler's saying the AI model should be the owner of the work, and the AI created the work for me as a work for hire. So Thaler loses on the registration. This is already going back to like 5 years now. Loses on the registration, loses on an appeal to the Copyright Office. Appeals, there's a different kind of appeal you can do, loses on that. You think Thaler would let it die. He goes, sues in district court, loses in district court. Same, again, always the same analysis, which is you need human authorship. That's the bedrock of copyright protection, and has now appealed that case. Thaler, as an aside, has done the same thing on the patent side, claiming that his AI model invented something and should be listed as the inventor of the patent. Has lost
Mm,
there as well. So, there's someone trying to like make a point and say the AI model should own it. There are a couple more interesting cases that have come since then. And at a recent webinar, the Copyright Office said they actually have not gotten that many AI registrations in the last year. You think they must be inundated with them. They said, not getting very many at all. So the two other cases that have been interesting, one was by a graphic artist named Castanova. She wrote a graphic novel, but then had AI generate the images for
mm,
them, and registers the work, doesn't say anything about the AI piece of it, and then goes and brags or publicizes the fact that she's the first person to get an AI work registered with the Copyright Office. The Copyright Office says, "Wait a second, we ask you a few questions, ask her about her process." Learns that indeed the graphic piece of the graphic novel were AI generated, and says you can copyright protect your original text. You can copyright protect the arrangement of what order you use these images in. That's
mhm,
scant but protectable expression.
mhm,
But you cannot protect the AI generated works themselves. And what came up in that case, and then shortly thereafter, in March of this past year, the Copyright Office came out with guidance about what is this all about? What do we mean here? What they said there in Castanova's case, and then said in their guidance, was the fact that you are putting in human prompts to generate an output is not sufficient human authorship to
mm,
create copyright protection. And their reasoning, which I personally think makes sense, and then Castanova's case, they had really good examples of this. It's still a random image, if you're doing images, a random image generator, meaning you put in a bunch of words, you get 4 images back, very different images, at least on Midjourney, which is the AI model she used.
mhm,
Now you think, I don't like that the sky's blue. I'm going to take out the word blue. It's not that you get the same images now with your new prompt, but it's now a red sky, not a blue sky. You get 4 entirely new images. And so they said, you're really, as a human, not doing much. It's not like you're tweaking the images little by little to get something. And so
mhm,
not protectable. The other thing they analogized it to, both in their guidance and in the Casanova case, is, well, why is this not like Photoshop? I'm a photographer. I take a picture. I go into Photoshop. I turn the background sky from blue to red. I erase out the lamppost that I don't think looks there. I play with the lighting. I do all these things. Why is this any different? And again, the view of the Copyright Office is, well, it is different because there you do need, you're using it as a tool. You're guiding the tool what to do for you. Um, you're not telling the Photoshop randomly make this photo more interesting and do whatever you want to do with it. And
mm,
every time you do that, it did something else. So not copyrightable as AI generated. The last piece of this puzzle is, okay, I get that. So now I'm registering a copyright, and it's not so black and white. It's
mhm,
not that it's entirely AI generated. It's not so much that it's human generated. It's not the easy, in air quotes, Casanova case where text she did, graphics she didn't do. What if it's, I don't know, a commercial? And in the background, in a scene, instead of having someone do some background, the AI generated the background. is this now an AI generated work not protectable, or is it human generated work? And how do I even register that? So
Mm,
the Copyright Office did this webinar where they went through that and said, you absolutely can register the work. You need to, as a human authored work, you need to disclaim the AI work. And their analogy, which I think makes sense, is just like you would disclaim anything in a registration. Let's say the background was the public domain. You might
right.
say background in public domain, background owned by someone else. I'm not claiming copyright ownership of that. And same thing here. AI not protectable, just disclaim it. One
Mm,
thing they have not been so clear about is their view is you need to do that, but if it's de minimis, you don't even need to say anything.
mm,
And the example they gave in the webinar is I shoot a scene in a movie. I realize there's a stain on the shirt of one of the actors. And instead of using Photoshop or whatever, I have an AI tool that can go through the movie, find the stain wherever it might appear in different scenes, and pulls it out. Their view is no need. That's just a tool. No need to disclose that. Um, and where the line is for that is still they're still not 100% so clear on. I think we'll get that over time. So that's a very long-winded, how we got to now of what's protectable and what's not under copyright,
mhm.
and how you'd actually go about registering a work where you used AI in part to generate your work.
I find this really fascinating because it takes me back to so many of those seminal cases that, we think about with respect to photography. It also makes me think of kind of like that Malcolm X case. I think it was the Spike Lee case in the visual space, the movie space,
Mhm.
and there, you can have hundreds of people that are contributing to this final work, but who might be in a position to actually register. And so that naturally makes me think of how, or I'd love your opinion or reflections on the different media perhaps driving a different result, or maybe it's just all going to be
Mhm.
the same, because some of the things in terms of selection that we take kind of in the still photography scenario. And then now we have a literary example with both text and photos. How might this play itself out in the increasingly digitized or digital generated creativity on the movie side, music, etc.?
It's a great question. And one of the cases the Copyright Office mentions is the Supreme Court case about, like, I guess literally the first case of can you own a copyright in a photograph?
Right,
And today we take that for granted.
right,
But when cameras first came out, there was at least a legitimate argument of you did nothing. So
right,
assume, let's take an extreme case. You didn't create like a still image on a table that you then photograph. You
right,
just go out into the park, stick your camera up, take a picture. Where the camera did all the work, where is the human creative element to that at all? And the Supreme Court's found that there was, and that there's enough judgment in
hmm,
the what time of day I took it, exactly where I put my camera, um, maybe how I set different settings. Back then I don't know if they had the extent of settings we have today,
right,
but there's some amount of human work that you do, which the court said allows you human authorship. Now what's
hmm,
interesting is the court didn't say you have human authorship in a photo over these components, but not those components, because that a camera just did.
right,
It's you own it lock, stock, and barrel. And with AI again, it's different. I will say, and the court even said this in the Thaler case that I talked about earlier, where Thaler said, "Well, the AI created the work." The court has this paragraph in the end of, we're kind of in a whole new world here, and this does not mean that this will always be the case. And you could imagine AI evolves or is used in a way where there is human authorship, and you
hmm.
should look at AI like you look at a camera. Um, it's hard to imagine what that would be like, but we're not there yet. But the court itself said, wait, watch this space.
Absolutely, because we know that technology is constantly ahead of the law. It's actually a feature, not a bug. As
Right.
it takes some
Right.
time to work those things out. I know it's easy from the tech side to say how far behind the law always is, but there's some reason for that, and there's some laws that endure for centuries and centuries, and some that are come squarely with the moment in time where it has to evolve, right?
Right.
This very well may be that moment where we have, because you think over the years about the different types of technology that has called into question the nature of authorship, the nature of sufficient permanence or fixation,
Right.
contribution, selection and arrangement, so many of the things that you mentioned. This is a very I have to sit back and kind of scratch my head to say, gosh, I hate to say it depends, or we don't
Mm.
know, but there's so many different ways to approach it. I did a lot of writing in the early in my academic career, hip hop and the law, and
Uh-huh.
and looking at some of those iconic, like it makes me think of Public Enemy and that iconic um, um, early album where there were hundreds of oral fragments, right?
Right.
That are in and of themselves individually, you can't even identify where they were sampled from, but putting
Hmm.
hundreds and hundreds of samples together where today no one could ever pay for what PE did
Hmm.
at that moment in time. And the argument at the time was using the sampler to analogize earlier to what you said of perhaps an artist in painting and putting things together in a way that might suggest fair use. I imagine some of the uh, uh, some of the defenses to copyright infringement are also tested. So I'm just wondering your thoughts, for example, of fair use and
Yeah.
something that is sufficiently transformative. I hate to
Hmm.
fall down that rabbit hole, but naturally that begs the next question.
Yeah. So I think that that gets into the final two buckets I was outlining at the beginning. It's great questions. So um, let's start with the quote unquote easier case, which is I do some prompt. Let's use the Casanova example, right? She's creating a graphic novel. She puts in a prompt, and it generates an image. She used the image in her graphic novel, and someone comes along and sees a graphic novel and says, "Wait a second, that's my image. That's like I didn't give you permission to use that." And Casanova says, "Well, I just put it through this. I put a prompt. Here's the prompt I put in, and it just randomly generated some images, and I didn't know it
Right,
was going to pick yours." Um, my view is that the copyright owner would have a very strong infringement case, and maybe not at the point of creation of the work, but once you start distributing it, copying it, you're doing that to an infringing work. The only thing that's interesting, and I think courts would look at it as good old fashioned infringement. Original
right,
work, new work, are these substantially similar or not? What I think it might be interesting when you can see arguments coming up is, and again, I'm using Cashnova just as an example, if she had done that, saying, I never saw you, I had no access to your work.
right.
Because copyright infringement requires access and copying. There are not that many access cases because almost always there was access. That's not the issue.
Mm,
There are a few music cases, where the songwriter said, "I never heard this song. I did not copy it." Copy it. Here, you could imagine Casanova even having a stronger argument than those music cases, saying, like, it's not like I generated an image from Star Wars, and how could I not know that when I put my
right.
prompt in, I was going to get this? I put in, old lady sitting at window with candle in a haunted looking house, and gray hair, and this is what I got. The AI model builders will argue the odds of that happening are pretty low. Um, Microsoft is willing now in their Copilot AI to give you a copyright commitment, which they'll indemnify you for exactly such a claim,
Wow.
unless it was your prompt that guided it to create an infringing image, or you fed into the model infringing images and said, create something like this. But so you just run it. They think the odds are that's never going to happen, or
Hmm.
the percentage is low enough that they're willing to indemnify you. But I think if that were to happen, you'd have a good case. So that's the quote unquote easy situation, right? The works look pretty similar. And now the question is, are there defenses? Because you're right, I'm selling a work that looks exactly like yours. Um, the more interesting case gets to our middle category, which is where the real battles are being waged in the intersection of copyright and AI, which is the way these models work is they were trained on tomes of publicly available, but not in the
Mm-hmm.
public domain, publicly available copyrighted content, mostly ingested from the internet, um, but copyrighted, protected material. The fact that they didn't go steal them, we'll put aside what terms of use might say, but they
Right.
took them in. And so the argument and then there's an important piece that I left out. They then put into a model. The model, if it's text, creates different weightings to understand how words are associated with one another.
Mm.
If you see the word forecast, chances are the word rain is going to be there, as a next or word after that. So it just creates all these weightings. It's just a big mathematical model
Mm.
of how words intersect with one another. Visual images work differently, but same idea. It just sort of creates these ideas behind how images look and things like that. So the copyright owners say, you've infringed my work. The model builders say, this is quintessential fair use.
Mm.
I totally transformed your work. It's not like there's little mini versions of a million photographs in the model. It is, there's a million mathematical models, in the model,
Mm.
or weightings or algorithms or diffusions or all sorts of different things. And I'm using it for an entirely different purpose. So, and there's no market here, and I almost like win on everything. It's fair use. There have
Right.
been a number of lawsuits that have been filed going exactly to this issue. The problem, and I think personally, we're 3 years out from a real decision in this because I think these cases will be decided, they'll be appealed, um, there'll either be a conflict, between the circuits or something that'll get it to the Supreme Court,
Mm-hmm.
and the Supreme Court will, put it on the docket, hear it in your decision. So, I think 3 years out till we get to there, and I think it's going to take that before we have some answer on this issue. Um, the better cases that have been brought in this area are ones that have said, well, here's how you're wrong.
Mm.
You've said you just used it as input and you created these weightings and it's got nothing to do with my work. And the Authors Guild is the case I'm thinking of when I say this. The Authors Guild did generated prompts where they were able to generate what would likely be infringing works of the original.
Mm.
So it's not like, look, you input all my books, but you never know that it was my books that were the input. It's just creating text about other things. They said, look, but if I can create the next in a series of stories, or a summary of the work that is pretty close to the work, you've now taken my work and used it for infringing purposes and not fair
Mm.
use. And where that line is and who's right in that, I think there are interesting arguments on both sides of that equation. I think the facts you're dealing with are very important. And as I said, I think that's where over the next 2, 3 years, the battles are really going to be waged.
That's really fascinating because when I
Oh,
think
sorry,
of,
Tanya, sorry to interrupt you. I left out one part because I want to
oh,
tie what I said a minute ago to this last thing. What a couple of plaintiffs, and they're all putative class action lawsuits. What a couple of plaintiffs have argued, which I think is a tougher argument, is if my works were part of the material that was ingested to build this model, even if it's a tiny percentage, by definition, every work generated is a
mm,
derivative of my work. And that I think is a hard argument.
mhm.
I'm not saying it's an impossible argument, but I think it might be a hard argument. It depends a lot on the facts. Um, but it's an interesting argument that everything is by definition a derivative of mine because my inputs are what allowed you to create that output.
That is, I'm so glad that you added that additional point because it was precisely what I was about to kind of opine on this. We've spent so much time in copyright jurisprudence analyzing what transformative use might be on the fair use side versus when you think of 106 rights with the adaptation right, which is what you are um, expounding upon, and how much would be sufficiently transformative to move away from a derivative work to something that is completely new. And this is really, I certainly don't say this often, and we can think of various points of technology, the piano roll, um, still photos, moving pictures, and all of that at a certain point where there's this tension that requires a result. And I think that you're spot on in terms of the way this issue will work its way through the courts and ultimately be decided in the Supreme Court. The final question, because there's so many different routes to this. You have, of course, the Copyright Office. Um, you have legislative initiatives that create enabling legislation for certain types of other agencies. You have independent agencies, and then you have the judiciary. And they all have to work together to formulate something that is workable for folks in this increasingly
Yes.
digitized age. It's just moving so fast. Stu, my head is spinning, and I like this stuff, so I can't
Yeah.
imagine what it is for others. Final question is just looking ahead. We kind of feel like we're right at the heart of this final question about key legal battles. So you've already articulated probably the pathway to SCOTUS weighing in on a host of issues. Are there any other key legal issues that folks on kind of all stakeholders should be aware of, or things that you've seen that people need to keep their heads up about AI and the intersection of AI and copyright?
Yeah. So on the copyright side, I think we've hit the key ones. I mean, I do think we might see an infringement case like the one I described, which is
Hmm.
infringing work generated, innocent infringer, and someone shows up and says that looks a heck of a lot like my work, and the defense being I didn't have access or it's AI generated, therefore it can't be. I think that'll be interesting. I think that's we've hit on some of the key ones. I think one that's a tangent to this issue, so not
Mm,
purely copyright, but one step removed, is cases where the plaintiff is arguing that my work came with certain license conditions
mm,
that you did not follow by using my work in your model. And
mm,
there's a case like this, which is I think a very interesting case. So a lot of the cases that have been brought so far have been about the fair use issue, have been in the text or image, like, graphic image categories.
mhm,
There's one case out there and that involves a putative class action of code developers, because that
mm,
our computer code was ingested into a model and like these models that generate computer code for you, just like they generate text.
mm.
And their code was all open source. So out there in the world for anyone to use, not protected by copyright, but open free license to use.
Right.
So your initial reaction might be, well, that's surely you could use because it's there for the taking. But all of that open source is under a license agreement which says you have to include a copyright notice that I'm the author. You have
Mhm,
to include a disclaimer that all rights reserved, whatever disclaimer you want to put in. There's certain conditions in the contract, my open source license contract, that you did not follow when you took my code and ingested it into your model. You remove my copyright management information under the DMCA, and you violated my license agreement when you used it. I think that's going to be an interesting area of litigation as well until this all gets
mhm.
sorted out.
Yeah, I definitely see that side of the data scraping issue and the inputs being a really big area of exposure for those who are developing in this space. It also makes me think of, because you mentioned earlier, the battle oftentimes around access and actual copying, and then substantial copying as a matter of law. That idea of access really changes when you're accessing a data model that you don't exactly know where things came from. We've never talked about intent in the copyright realm. I wonder if there will be some
Mm-hmm.
area for that, given the fact that so many people are accessing, no pun intended, large language models for output without having an appreciation for the input. which raises all sorts of interesting questions that I have no
Yeah.
answers for, but definitely will be interesting to see.
Hmm. Yeah. I mean, I will say one thing which, which everyone can take some amount of comfort in, and I'm sure people might, disagree about this, but the Copyright Office is very on top of this issue. I don't
Agreed.
feel that they're asleep at the switch, not paying attention, giving it the back of their hand.
Hmm.
They're taking it seriously. They've, have folks working on this issue. They just put out a notice of inquiry asking the public to comment on a whole variety of areas in this area. They got
Hmm.
10,000 comments. I think a good number were,
Oh my gosh.
people just riffing on AI.
Right.
But
I wonder if
they
some were AI generated. I don't know.
yeah, exactly. Yeah, that's a good point. It's a great point.
Very
I'm sure
meta.
yes. But I think they're very very well focused on this area.
Stu Levy, thank you so much for joining me again. We will have many opportunities to come back and to wonder about these things, but I'm grateful to have you kind of out there on the leading edge of it to help keep your clients safe and the evolution of law in this area moving forward. So thank you very
Great.
much.
Yeah, thanks for having me, Tanya. Great discussion.